Well, hello, and welcome to this 3PB update seminar for probate. I'm Cheryl Jones, a member of the probate team, and I have the privilege of hosting you today. Before we start, I'd just like to run through a little bit of housekeeping. We will be taking questions at the end for about 15 minutes. We already had a few questions in advance, but if you do have a question you would like to ask, then please do use the Q&A button, which you should see at the bottom of your screen on the right-hand side. Please don't use the chat function. We do have a large number of people signed up for today, but we will answer as many as we can as we go along or at the end. We will also be distributing notes and PowerPoint slides later on today. When I say we, I do of course mean in terms of distribution, our marketing person, Delphine Avondo, and in respect to the questions, our two speakers for today, Lydia Pemberton, who is a full member of STEP and who acts for clients ranging from personal representatives of small estates right the way through to estates which have an international aspect. She also acts in respect of high value complex estates, and she will be talking to you on the subject of put up or shut up, how to progress estate administration. She will be giving an overview of the options which are available to personal representatives who need to progress the estate administration when there are adverse or competing claims from outside the estate, something which can cause a great deal of difficulty if the incorrect steps are taken. Firstly, however, you'll be hearing from Martin Strutt, one of our senior chancery practitioners who specialises in contentious probate. He is going to be telling you whether or not a lack of knowledge and approval by a testator can be cured by way of rectification of the will. This, I have to say, is something I am looking forward to hearing. And so without further delay, Martin, I'm going to hand over to you now.
Yes, good morning, everybody. I'm going in this talk to give you an overview of knowledge and approval and rectification, where those two matters coincide. And I should say at the outset that there are written notes that I've prepared for this talk. They will contain all the references to the cases that I will be referring to, and you will, I think they will be emailed to all those who have subscribed to this talk. Anyway, to start my talk, by way of introduction, as I'm sure most of you will know, that contentious probate, certainly in the last 20 years, has become very much a growth area of litigation. And this really has come about, as I see it, for two principal reasons. Firstly, the context of such litigation originates from usually disputes within families. And of course, that means that family members often have a sense of entitlement and feel very strongly if they perceive they've been dealt with unfairly in the will of a parent or another family member. And my experience is very much that inter-family disputes tend to be one of the most acrimonious forms of litigation when families, everything is all very happy when parents are alive, but when the last parent dies and the children then see some money possibly coming their way, that often is the catalyst for what can become very acrimonious litigation. And in effect, the combination of family passions and money is a toxic combination very often. However, I think probably the main driving force of contentious probate litigation is the size and value of estates nowadays. That, of course, effectively results from the exponential increase in the value of property. And you don't have to be regarded as particularly wealthy if you own a house to actually have an estate that may well be worth in excess of $500,000, mainly deriving from a property that the deceased owns. And of course, what that means is that those who think they should be getting a benefit from the estate feel that there's something worth fighting about, although, of course, and this is a salutary point, it doesn't take long if you go to a contested contentious probate trial for legal costs to make very significant inroads into that estate. Now, as you will know, that contentious probate involves challenging wills, and there are a number of different grounds on which wills can be challenged, and that includes testamentary capacity, undue influence, fraud, what is sometimes rather delightfully called fraudulent calumny, in the way that the Victorians like to characterize these things, and of course, knowledge and approval. And it's my intention to concentrate in this talk on knowledge and approval. But what I would say is this, that in all forms of contentious probate, and not least where knowledge and approval is an issue, it is very instructive to read part of the judgment of Lord Justice Mummery in the case of Hawes and Burgess. And I think all of us in the contentious probate area of law, we all regard Lord Justice Mummery, along with one or two others, as being a very well-regarded judge in these areas. And he was dealing with a case that did involve testamentary capacity and knowledge and approval. And he sort of summarized the issue as to whether the particular will in question, did it arouse the suspicions of the court, as to whether the contents truly represented the wishes and intentions of the deceased. And then the second question that was being asked was, did the scrutiny of those circumstances by the court dispel those suspicions? And then he said this, and I will read it not entirely in full, but he made the point that in these cases, the court has to consider and evaluate the totality of the relevant evidence from which inferences can be drawn on a balance of probabilities. And he made the point that presumptions, which in days gone by were a very popular way of addressing these issues, that the presumptions are perhaps less well regarded by the courts now. They look at the whole of the evidence, don't really rely on presumptions. But he made the point that courts realistically recognize that if a properly executed will has been professionally prepared on instructions, then explained by an independent and experienced solicitor to the maker of the will, it will be markedly more difficult to challenge its validity on the grounds of either lack of mental capacity or want of knowledge and approval than in a case where those prudent steps have not been taken. And he also went on to say, which I think is again a very something well worth bearing in mind. He said, I should add a statement of the obvious in order to dispel any notion that some mysterious wisdom is at work in this area of the law. The freedom of testation allowed by English law means that people can make a valid will even if they are old or infirm or in receipt of help from those who they wish to benefit, and even if the terms of the will are hurtful, ungrateful, or unfair to those whose legitimate expectations of testamentary benefit are disappointed. The basic legal requirement for validity are that people are mentally capable of understanding what they are doing when they make their will, and that what is in the will truly reflects what they freely wish to be done with their estate on death. And that, in my view, is a brilliant summary of the validity of wills, covering really all aspects. And I would suggest that any practitioner who is considering challenging a will reads that part of the judgment in Hawes and Burgess with some care. Now, turning specifically to knowledge and approval, what is knowledge and approval? Effectively, the testator must have known and approved the will and its dispositive provisions. So, what is actually meant by this? There is some judicial debate in the textbooks, but effectively, the better view now is as set out in Gill and Woodhall, a judgment of Lord Newburger, another very highly regarded judge, as I'm sure you will all know. He said that the testator must understand what is in the will when he signed it and what its effect would be. And that was approving an earlier case of Hoff and Atherton, another Court of Appeal decision in 2004, where it was said a testator cannot be said to know and approve the contents of his will unless he is able to and does understand what he's doing and its effect. And then it says, it is not enough that he knows what is written in the document which he signs. So a testator must, even if a will is read over to him and he approves it, if in fact, because of some drafting error, it doesn't represent his intentions, I think the better view is that there will not, in those circumstances, be knowledge and approval. I should add this, of course, that that concept must be looked at in this context, where you get an expert draftsman to formulate the testator's instructions, and he deploys somewhat esoteric and appropriate legal language. The fact that the testator might not really understand the language used by the draftsman, that doesn't mean that he doesn't have knowledge and approval of the will, because in such cases the testator is deemed to have adopted the language in the will, and knowledge and approval is imputed to him. And the authority for that is Greaves and Stolkin. As to proving knowledge and approval, I set out a number of principles. Of course, in the vast majority of cases, there is an evidential presumption which still stands, notwithstanding the observations I've made about the court's current reluctance to set too much store by presumptions, but there is an evidential presumption of knowledge and approval arising from proof of the will being duly executed by a testator with testamentary capacity, and that is set out in a number of cases, including Sherrington and Sherrington. That presumption derives in turn from another presumption, which is the presumption of capacity, where the will is duly executed and rational on its face. Of course, the reality is that in many cases, the witnesses and the solicitors who prepared a will may be long dead or untraceable. And of course, in those cases, wills are routinely admitted to probate in common form on the basis of those presumptions without any actual substantive proof of knowledge and approval. However, the position is different where there is a challenge to knowledge and approval. And in those cases, as set out in Gill and Woodhall, again, the view now is that it's really a single stage test. It's not these shifting presumptions. The single stage test is, has the testator understood what was in the will when it was executed and what its effect would be, which I've already indicated. And in determining that issue, the court looks at all the circumstances of the case. And again, in Gill and Woodhall, repeating what I've already said in Hawes and Burgess, where a will has been professionally prepared and read over to the testator, that raises a very strong inference that there has been knowledge and approval, if not an actual legal presumption. And if there's no countervailing evidence, knowledge and approval will be inferred. Now, in the textbook and reported cases, there are a number of factors that tend to suggest a lack of knowledge and approval. And where those factors are present, the suspicions of the court are aroused, and the court will be vigilant to ensure that actual knowledge and approval is established. And in those cases, the propounder of the will must produce positive evidence of knowledge and approval. How compelling and persuasive that evidence needs to be will depend really on the extent to which the court's suspicions are aroused by the circumstances in which the will is executed. And I give a number of examples of the factors where suspicions are aroused, and I'll set these out quickly. For instance, where a testator is blind, dumb, or illiterate, where his mental capacity is impaired, albeit not to the extent of lacking testamentary capacity, where the will is drafted by a person who takes substantial benefit under it, where a person is actively involved in procuring the making of a will under which he takes a substantial benefit by suggesting the terms of the will and choosing the solicitor to be instructed by the testator. Another example is where the terms of the will represent a radical departure from long-held testamentary dispositions, particularly where the person whose favour the changes are made is involved in procuring the making of the new will and has some influence over the testator. Then there are the cases where substantial benefits are conferred on carers. I had a case where a carer, a 94-year-old testator, gave her a legacy of $1 million. We settled the case at 600,000. And another example is where the beneficiary of the will is a doctor or solicitor or someone in a similar position vis-a-vis the testator, and that person is involved in procuring or executing the will. So those are the cases where suspicions of the court are aroused. Finally, on knowledge and approval, you can have knowledge and approval of part of a will, and then you reject the other parts, although it was said in Fuller and Strum that circumstances in which you could have knowledge and approval of any part of a will would be extremely unusual. So I turn now to rectification. So as I've said above, where there's been an error in the drafting of the will, this may have the result that the testator does not have knowledge and approval of the will as drafted, to the extent that he cannot be said to have understood its legal effect. Now, where that happens, a rectification may save the will. And there are a number of ways this happens, and there are two statutory provisions set out, section 20 and 21 of the Administration of Justice Act 1982. Now, section 21 is the sort of construction point because that provides that where any part of a will is meaningless or ambiguous, extrinsic evidence of the testator's subjective intentions may be adduced. And I'm sure you all know that that's a departure from the usual rule of construction of legal documents, that the subjective intentions of the parties are actually not admissible. And there is a case in Brooke and Purton called Brooke and Purton, where it was held that ambiguity should be given a very wide, broad construction. However, there may be cases where you can't cure the problem by deploying Section 21 and construction, and then in those cases it may be possible to resort to Section 20 of the Act, which provides that where the court is satisfied the will as drafted fails to carry out the testator's intentions due either to a clerical error, firstly, and secondly, a failure to understand his instructions, then the court may order rectification to carry out those instructions. Now, dealing firstly with a failure to understand the testator's intention, I think it's acknowledged that this that provision is of somewhat limited scope, because it really applies to cases where the drafter of the will has failed to understand the instructions given. It doesn't cover circumstances where the draftsman fails to understand the legal effects of the words he uses, or uses the wrong technique in drafting, where he does in fact understand the testator's instructions. So if you can't use a failure to understand the testator's intentions, you then come to the clerical error exception basis for rectification, and that has received the attention of the Supreme Court in Marley and Rawlings in 2014, which is the only case on rectification to go on to the House of Lords of the Supreme Court, and they upheld there the definition of the expression clerical error set out in a case called Bell and Georgiou, where Mr. Justice Blackburn said the essence of the matter is that a clerical error occurs when someone who may be the testator himself or his solicitor or a clerk or typist writes something which he did not intend to insert, or omits something which he intended to insert. The remedy is only available if it can be established not only if the will fails to carry out the testator's instructions, but also what those instructions in fact were. Now, in Marley, it was held that a will which was invalid by reason of a drafting error, which would result in a finding of lack of knowledge and approval, that could be cured by rectification. So an invalid will by reason of lack of knowledge and approval, that can be cured by rectification. The reason they really gave for that was that the Supreme Court said that Section 20 should be construed as widely as possible, because the general thrust of Part 5 of the Administration of Justice Act, in which Sections 20 and 21 are part, the whole thrust of that part was to make it easier to make a valid and effective will. And they also held that Section 20 wasn't confined to correcting drafting errors, but it could extend to other sorts of error, mistakes resulting from the way the will's been executed. And of course, in Marley and Rawlings was the case where the husband and wife made mirror wills, and accidentally the husband signed the wife's will and vice versa, and the Supreme Court said that's fine, that's a clerical error. However, I think the general view is that Marley and Rawlings does not mean that Section 9 of the Wills Act can just be ignored now. I think the particular facts of Marley and Rawlings were wholly exceptional. Finally, though, what I would say is that it seems to me the effect of Marleyan rulings is that most drafting errors, which would otherwise result in a testator lacking in knowledge and approval, they can now be cured by the very wide interpretation of the meaning of clerical error. That is the end of my overview talk on knowledge and approval and rectification. I will now hand back to Cheryl.
Thank you, Martin. Thank you. That was really interesting. We're now going to turn to Lydia, who, as I said earlier, is going to tell us about what to do when there are competing claims. Lydia.
Thank you, Cheryl. Right, can everybody hear me? I'll take a thumbs up, thank you. And can everybody see the screen? Perfect. Just by way of segue between our talks, if I may, I was prompted by Martin's talk to the case of Re Boys from 2013, which was a decision of Mrs. Justice Proudman. And there's a really good quote that I've used in opinions before at paragraph 137. And she says, the problem in this case, as in so many, is that the parties seem to think that a judge can look into the hearts of the witnesses and somehow divine the truth. That is not how the system works. A judge can only find facts on the evidence properly adduced. Indeed, sometimes where the facts cannot be determinatively ascertained on such principles, a case may have to stand or fall by default on the burden of proof. I cannot tell what actually happened. I can only, as I've said, find facts on the evidence. So with that in mind, what do we do when we have estates which pre-grant or post-grant are struggling to be administered because of problems being introduced by competing claims from people primarily saying that the will is invalid and seeking an earlier will to be pronounced for, or because there is an intestacy which will fall otherwise. So I'd like to talk in respect of two topics. Probate claims, so will challenges pre-grant and will probate claims challenges post-grant. I don't pretend for a moment that the suggestions and the options I give are exhaustive in any way, because there are multiple ways to skin a cat when it comes to trying to undermine the will of a testator. What I want to do is talk in probate claims pre-grant. There are some suggestions that can be made, and these fall into the non-contentious probate business, which is the principal registry or the probate registries, which is the High Court, Family High Court, or through the contentious business side, which is the Chancery Division. So I've just helpfully lost my screen. Just bear with me one moment, please. Right, so probate challenges pre-grant. The suggestions I make are not exhaustive, but they should appear on the screen. So when we're dealing with the first one, Rule 44.13, Rule 44 is of the non-contentious probate rules 1987. Rule 44 deals with caveats or caveats, depending on how you want to say it. So a caveat is entered in Form 3, a warning is entered in Form 4, and then in respect of the next step, the caveator or caveator has two choices. If they have a contrary interest to the will, i.e. they say there is an earlier will which should stand, or they take an interest under an intestacy, then they enter an appearance in Form 5. If they don't have a contrary interest, then they can issue a summons for directions, and a person doesn't have a contrary interest if they accept the validity of the will, but don't, for example, accept that the appointed executor should take out a grant. So in that situation, it's essentially a precursor to a Section 116 discretionary grant being made in favour of another person. The rule at 44.13 shouldn't be overlooked, because what it provides for is that once a caveat has been made permanent, so termed, there still remains the option for the person seeking to obtain a grant to issue by summons the person who's entered the caveat to attend before the registrar or the judge, essentially to show cause as to why the caveat should remain in force. I've found that this can in certain situations be particularly effective and particularly cheap. So when you have a reluctant person who is refusing to withdraw the caveat but doesn't really have the bones of a case, they can be summoned before the registrar. And I've been there before where it's been dismissed and the caveat's been vacated because the person just doesn't really have anything to go on. Alternatively, if it looks like there may be the bones of something, but the person is just delaying, what the registrar or district judge can do is make what is in effect an unless order to give them a period of time in which they have to issue a probate claim, failing which the caveat will be vacated. This use of Rule 44.13 is obviously only limited to situations where somebody is really dragging their heels, or what they have said just doesn't hold any real water. If the unless order is made in the probate registry, then the caveator doesn't then issue probate proceedings, then the cost that the person warning has gone to will fall at the caveator's door. If they do then issue proceedings, then usually those pre-litigation costs fall within the validity proceedings themselves. The downside, of course, is that by using this process, there isn't any permanency. And as I will say, touch on later on, this is because when one obtains a grant in common form through the probate registry, through the family division, that theoretically can be challenged for the rest of time because there is no statutory limitation period on that. If an executor or beneficiaries under a will want to prevent there being a subsequent challenge, what they have to do is seek a grant in solemn form, which can then only be later revoked in the event that A, it was obtained through fraud, or B, there was a later will. So the second option, this is when we move into the contentious business side, and this will be in the Chancery division. The second option is pre-grant for an executor or beneficiary to simply say, well, I'm going to go and seek the will in solemn form. It has to be remembered, though, that beneficiaries cannot compel an executor to take that step. Probate claims under Part 57 put the ball firmly in the court of the person challenging it. So upon receipt of the probate claim, and it's a specific procedure, it's a different form, and it's a different period of time that you have to acknowledge and put in your defence at the same time. There are essentially four options for the challenger. They receive the probate claim and they concede. They receive it and they contest. Thirdly, they can use the option under CPR Rule 57.75, which is that they give notice that they don't raise a positive case, but they insist on the person propounding will to propound it in solemn form. If that's a reasonable step for them to have taken, then all things being equal, they won't be forced to pay the costs in the event that they are unsuccessful, unless they didn't have reasonable grounds for taking that stance. And the fourth option, of course, which is always open to a defendant in litigation, is simply to ignore it. What happens in probate claims is slightly different to the rest of the procedure. Default judgment is not available, but what the person propounding the will can do is ask the court to direct the matter to trial on the written evidence alone. So that's the second option. The third option is that an executor or the beneficiary can cite, oops, sorry, I've gone too far through, can cite the executor of the later will to propound it. And that basically means we say that we've got the valid will, you're saying there's a later will, and what we're going to do, we're going to cite you under Rule 48 of the non-contentious probate rules. So we're back in the probate registry and family division here. I'm going to cite you to propound that later will because I have a genuine belief that it's not valid. If that person does not then seek to propound that later will, the executor or the beneficiary under the earlier will can proceed on the basis that the later will was invalid. And so that's an option available, again, within the probate registry. A slightly unusual one, which I have no experience of, either directly or indirectly, but obviously having to read around this topic for today's talk, did come across the suggestion that what can be done is that those claiming under a previous will can issue the Part 57 probate proceedings for an order pronouncing for that earlier will. But if that fails, they can ask the court to admit the will he propounds to probate in common form. I have to confess to not readily following how that works, but the authors of Williams say that it's less common. So as far as I'm concerned, if they say it's less common, I don't believe that I need to be troubling you with it any further than simply by way of flagging it. Finally, the final suggestion pre-grant is that where you have no question over the validity of the will, but there is, and if you, because you don't think there's a later one, and if you did, and you question that validity, you'd use the Rule 48 procedure. But where you don't question the validity of the will, but you do question the validity of a codicil, the correct course in that situation is not to cite the executor or persons interested under the codicil, but actually to seek the will in solemn form, a grant of the will in solemn form in probate proceedings, along with a declaration or decree pronouncing against the codicil. And the reason for that is because underpinning all of this is that an executor's role, and this is all primarily driven towards executors and the will challenges, because an executor's role is fundamentally to carry out the last wishes of the testator. So if there is a codicil, i.e. a testamentary document subsequent to the will, it is incumbent on the executors to satisfy themselves as to whether or not it does represent the testator's last wishes. And if they have reasons to believe that it's invalid, then they need to adduce satisfactory evidence to the court to demonstrate that. So we've got a grant and we've got it in common form. Probate claims under Part 57 are strictly in three. So we may use probate claims as an umbrella, but within the CPR, we're strictly speaking about three types of claims. They're claims asking for a court to pronounce for or against the validity of the will in respect and to seek a grant in solemn form. They're interest actions, or also known as interest suits, and they're claims for revocation of the grant of probate obtained, or the grant of letters of administration already obtained. So my focus is on the revocation. So as I've already stated, there is no statutory limitation period in respect of revocation. So the danger to a personal representative, be it an executor or an administrator, is that sometime after the estate has been fully administered, a beneficiary or those claiming a contrary interest will come out of the woodwork and seek to overturn the grant. Now, Section 27(1) of the Administration of Estates Act 1925 provides protection for personal representatives where they act, quote, in good faith, end quote. That protection is twofold. It means that if they've made dispositions or payments and the grant is subsequently revoked, providing they have been made in good faith, there'll be no comeback and personal liability on the PR. The second protection is afforded that where the PR has been taken their expenses or their proper remuneration because they are a professional, then they're entitled to keep it because they did it all in good faith. And when we're talking about good faith, that term is obviously debatable in a number of contexts and it is subject specific, but we're talking about good faith because a PR has operated on the basis that they have no reason to doubt that they are administering the estate in accordance, in this context, with the testator's last wishes. So at the one end of the spectrum, we will have scurrilous, vexatious, ill-founded claims, which are so ill-founded on their face that most executors shouldn't be concerned that they can proceed with the administration of the estate without troubling the courts for any sanction to do so. And then, of course, we've got claims, will challenges at the other end of the spectrum, which are have so much teeth, or there's so much flesh to the bones that the executor says to the beneficiaries, we need to sort this out, you need to sort it out between yourselves, otherwise I need to take the matter to the court for directions as to what to do here. And in between those two situations, spanning that divide, are all other cases. So what I suggest are two options. And this obviously only applies to an executor. Even where an executor has got a grant in common form, they can, quote, for their own convenience, end quote, go to court and seek a grant in solemn form to rid themselves of the challenge once and for all. They can't be compelled to do that, and one has to query why they would incur the costs of a fully fledged probate claim when they already have a common form grant. But I have been on the other end of a couple of cases of this nature, where basically executors are sick to the back teeth of what's happened and just want to, it's a similar put up or shut up point. But actually the second suggestion I have, and it's the cheaper option on the face of it, is to basically tell the person challenging the will to put their money where their mouth is. So when we come to put up or shut up orders, we have two cases to go to. Sherman and Fitzhugh James, which 2003 decision. It's a very lengthy judgment, but it's worth a read. And I say worth a read only in the legal context. I don't suggest for a moment that anybody should be doing this in their own personal time. And the second is Cobden, Ramsey and Sutton. And so if we hear somebody saying we'd like a Fitzhugh Gates order or a Cobden Ramsey order, what we're talking about are these put up or shut up orders. They're very similar in nature to a Benjamin order. So the case of Re Benjamin going back is when they couldn't ascertain the beneficiaries. It has a wider application, and it basically means if a personal representative wants to distribute the estate on the footing that a certain event has or hasn't occurred, or that the beneficiaries are or are not alive, etc., they can go to the court and say, sanction me to do it this way, and if you grant me that sanction, I know I have the personal protection when I make that distribution. That doesn't stop, of course, the rightful beneficiaries thereafter making a challenge and seeking to recover the estate assets from the people to whom they've been given. It's all couched in protecting the PRs from personal liability for doing something they shouldn't have done. So Sherman and Fitzhugh Gates affirm when it got up to the Court of Appeal, it was actually an appeal in respect of the wasted costs order, which had been ordered against the solicitors representing the executor. There were 3 appearances in court, one before the master, then on appeal to the High Court. Then the wasted costs order was made, and then it was an appeal from the wasted costs order. But Sherman and Fitzhugh Gates is a really good case by way of chronology to set out just how patient this executor had been in offering the opportunity for the challenger, Claudia Sherman, also known as Borden, to basically set out her case. So her uncle had died in 1994, and he'd made a mirror will with his sister who'd predeceased him. And after she died, he then changed it so it wouldn't be left to Claudia and her 2 siblings, but it was going to primarily, subject to a small pecuniary legacy to Mrs. Perkins, the executrix, was going to go to animal welfare charities. And these estates were nominal. In fact, I think certainly the sister who'd predeceased him was an insolvent estate, and his estate was certainly, the game not being worth a candle is probably a nice way to put it. But he dies in 1994. By 1998, Claudia Sherman, who had been alleging lack of capacity, undue influence, etc., had still not put her cards on the table. So in 1999, following an originating summons by the executrix, the matter went before the master, there was 2 points. One was an issue of severance of the tenancy, joint tenancy, which had been held by the deceased and his sister, because if it had been, their joint ownership had been severed, then the sister's 50% share would have fallen into her estate, which would actually have benefited Claudia Sherman as well. So that was the issue which was dealt with by the lower court, but it was the issue of capacity that still loomed large. But what the master said, and I think properly, he couldn't rule on the capacity challenge, because what had happened, the Mrs. Perkins for the executrix had asked the court to direct whether or not this Claudia Sherman had an interest in the estate. Basically, the judge said, that's not what I can do here. I can't answer capacity. So he said at 23, I think it's not possible for me under the guise of an inquiry as to whether or not she has an interest to determine whether or not the will should be valid. And what he directed the Claudia Sherman to do at that point was to bring probate proceedings. And when I say direct, I don't mean any formal direction in the court order, which in this situation was problematic, because it turned out that Claudia Sherman wasn't thereafter told what the master had said. Claudia was in Canada and she hadn't appeared in person. But by that point in time, we were 5 years post-death and still no probate claim on the table. The matter went up to the Court of Appeal, and it is worth reading the paragraphs 50 odd onwards, because this is where Lord Justice Carnworth talks about these put up and shut up orders. So what should an executor do when they have a challenger who is just refusing to put their cards on the table or nail their colours to the mast, or whatever the appropriate metaphor is in these situations? The executrix's hands were tied. She couldn't distribute the estate in the knowledge that in the background there remained at large this issue over the capacity. But equally, she couldn't delay, because she had an obligation to duly administer the estate in accordance with the will and give the residue estate to the welfare charities. So the judge said, the textbooks do not appear to offer an easy solution in such circumstances. There's no statutory time limit for proceedings, but it seems an action may be struck out for unreasonable delay. And this is where he says, the powers of the court to control abuse and delay have been strengthened by the new CPR, and I see no reason why they could not have been used to impose a time limit on a potential challenge to the probate, in effect a direction to put up or shut up, following which the executor would be free to distribute under the will. And so that's where we get this notion from. So today, if you realise that you've had on your books this potential challenge for a period of time, that they've had sufficient time to explore, sufficient time to investigate, the executor has been as forthright with information as is appropriate, that actually what you do is say, I'm now going to issue my Part 8 claim, proceeding under CPR 64, and I'm going to seek a direction from the court that unless you do by 28 days issue a probate claim against me, I'm going to distribute the estate on the footing of the will. And that, as I say, should be, in theory, a cheaper way than putting the executor to the cost of getting a grant in solemn form. Just briefly and finally then, Cobden, Ramsey and Sutton, it was a decision 6 years later. The challenge by the residuary beneficiary on the particular point was them saying that the court, there was no statutory basis for the court to order that somebody either makes a claim or they didn't. And if the court's going to have that power, it has to have its footing in statute. His Honour Judge Berens disagreed and said, I'm going to make the order. It's going to be, you have 28 days to do this, and I'm not debarring you from bringing the claim. What I'm doing is in respect to the executor's role, and I'm permitting the executor to distribute the estate. It doesn't stop you making a challenge. Again, as I've said, what it does, it protects the executor from the challenge from the beneficiaries if they distributed an estate and they do it on the wrong basis. So I would urge everybody to bear in mind, when we have reluctant challenges, but those who won't go away, to warn them that the court has the power, and are quite easily persuaded, in my experience, to make such an order because it is efficient, it is usually proportionate, and it ensures that everybody can move on with their lives. So therein ends the lesson.
Thank you very much, Lydia. Very interesting. We've got a number of questions that have come through, and we'll take as many as we can in the next few minutes. But there's one very relevant one, Lydia, which I'd like to start off with you. And this is a question which I think might be quite helpful following on. Can put up or shut up orders be made prior to obtaining a grant of probate? If not, what is the best way and what is the procedure, please?
Thank you, Cheryl. So I think my answer to that has to be no, because what you're asking the court to do in a put up or shut up order is going before the Chancery Division as the executor of the estate. So whilst the power vests in the executor from the date of the will, ultimately no real distributions can be undertaken until there's a grant of probate. So I would urge that if there's a caveat in place, you use Rule 44.13 and summons. If that doesn't get rid of them, then you can, if you have a genuine belief, so if you are satisfied on a proper basis that the later will that the challenger seeks to prove is the valid one, then you can cite them. But if there isn't a later will and they're saying just this will doesn't stand, then I think the first protocol has to be the 44.13 procedure, which is a similar thing. It's just it's the put up or shut up order in a different guise, because the registrar will be given the 28 days to issue a probate claim rather than the Chancery Division post grant giving 28 days to issue the claim before the distribution can be made. So my answer would be no, it can't be used until a grant.
Thank you very much, Lydia. Martin, I have a question from you or for you. It comes in three parts. I'm going to just read it all out because I think you can give perhaps a composite answer. So it's this: what can a testator do to ensure when making a will that their wishes are adhered to as far as possible, to stop or reduce a wayward executor deviating from the will? How can an executor overcome some beneficiaries from delaying to a certain degree, reading and distributing legacies to other entitled beneficiaries? And how can a testator or testatrix best be guided to accepting it may be a good idea to make a lasting power of attorney at the same time as making a will? I hope that was clear. I think I garbled the middle bit of it, but I think you get the general idea. Martin, you're on mute.
Yes, sorry about that. Yes, as far as a testator, what he can do to ensure that his wishes are adhered to stop or reduce a wayward executor deviating the will. Well, I mean, the first obvious point is be careful who you choose as an executor. Don't choose someone who you think might deviate. And obviously, in that regard, maybe the best way of doing that is to appoint a professional to that role. In other words, a solicitor or an accountant. There may be some expense involved in that, but at least you know that because of their professional status, they are unlikely to deviate from the terms of the will. I mean, otherwise, the fact is that a will creates a trust, and the executors are legally obliged to implement the terms of the will because they are entrusted to do that. And if they don't, the relevant beneficiaries have claims against them. But I mean, I don't think there's really anything more that a testator can do at the time he makes his will to stop that happening. As regards beneficiaries delaying, I mean, it slightly depends on the context in which that is being done. I mean, clearly, the executor is the person who has legal control of the estate, and he is the person, he or she, they are the persons who have the right to distribute get in the estate, pay the debts, and then distribute it according to the terms of the will. And so, I mean, in theory, a beneficiary doesn't have any power to delay that process. I mean, there may be cases where a beneficiary perhaps has an beneficial interest in a property jointly owned with the estate and might try and remain in the property. But in those cases, really, the executor, if necessary, would have to take proceedings, maybe under TOLATA, to force a sale of the relevant property so that the testator's share can be distributed under the terms of the will. So far as the final point about LPAs, well, I mean, it depends upon really when a will is being made, because in my experience, if you're dealing with people, say, under the age of 60, I mean, that's a broad generalization, but very often when they make wills, lasting power of attorneys are very far from their mind, and they're probably unlikely to think of doing it. These things generally come about either because there is a particular medical problem or people are getting old. I mean, clearly, I think as a general proposition, if you've got someone who you trust, then an LPA is probably a good thing. But again, as with choice of executors, most LPAs are granted to family members, but I have seen cases where they have been abused, and then you get an enormous battle between family members when after death as to whether the deceased estate has been wrongly depleted by the actions of the attorney. So I think it's difficult to give a general answer to that, but clearly there are practical advantages to having the LP in place when you're dealing with elderly people. So I think that's probably the best answer I can give.
Thank you, Martin. Lydia, I have another one for you. It's a fairly short one. If an estate is insolvent due to the debts outweighing the assets, how can a creditor, I think it should be, get the money from the assets without probate?
I think the answer to that must be they can't. There must be a grant of probate, and if there's one already but the estate is insolvent, then the creditor can apply and should apply for an insolvency administration order, because the deceased estate and whether it is insolvent is to be treated in the same way as if the bankrupt were living, and the same tests will be applied. And of course, what a creditor after death cannot do is the same that a creditor pre-death can't do. It is take a preferential payment, and that once somebody is bankrupt, everything gets thrown into the pot and people get paid out, generally speaking, on a pro rata basis. So I think the answer has to be that to do things properly, there has to be an insolvency administration order, and the debts and expenses get paid in the usual manner.
Thank you very much. Well, we're coming towards the end now. Unfortunately, time does fly past. So I'm going to wind up now. I don't think we've got any outstanding questions on the Q&A that haven't been answered. So thank you all very much for attending today, and particularly thank you to Lydia and Martin for very helpful and instructive talks. And we hope to see you at the next 3PB Barristers webinar. Do keep an eye out for us. We like to think we give good value. And so it's goodbye from me, and it's goodbye from them.